So this is your motion, Mr. Shears. I have read your motion, and I have also received a response from Ms. Lachae, and I've read that as well. So my first question will be with the plaintiff. Have you received a copy of the motion, Ms. Lachae?
Yes, I had to go down to the court. Oops. Can you see me? My screen is freezing.
Yes, I got you.
Okay. Yep, I got it from the county clerk.
Okay.
Last week Friday.
And
What did you
Mr. Shears, did you receive a copy of her response?
No, I have not.
Your Honor, I do have a receipt here from the Postal Service saying that it was mailed to that address.
Okay, it says, well, and there's a proof of service that says 725. But do you two generally communicate at all, or are you two not even doing that?
No, Mr. Shears, he does reach out to me on Messenger, so he does initiate communication on his end, but I do not respond.
Okay, I am, because what I would like to have done is I would like him to have a copy of your response, and I'm trying to see how the best way to get that to him, whether it be in the mail, but the easiest way to do it is to scan it and email it, so he gets it immediately. Do you have an email address, Mr. Shears?
Yes, I do.
Why don't you give it to me?
It's my first name, Jelani, Jelani, Shears, SHEARS @iCloud.com.
You got that, Ms. Lachae?
Yes.
Okay, so just scan it and ship it over by email, and then he's got it, and you can read it later today, Mr. Shears. But I have read your motion. Is there anything you would like to add to the motion before we hear from Ms. Lachae?
No.
Okay, thank you. Ms. Lachae, your thoughts, please.
Because I don't want to go on a tangent. However, with me receiving this last minute, I did not have enough time to allocate evidence to show, but showing up today as in good faith, I always try to do what's best for the children. We have a FOC case as well. On the documentations, it will show his inability, like there's a pattern. He doesn't have a stable housing. I'm unsure why he did not receive the motion because I used the address that was listed on the motion. Also, him filing incorrectly. I'm also looking into getting his rights terminated because this has been a lot where the kids are in therapy. I've gone to therapy myself, and yeah, I just don't want to go on a tangent. That's all I want to say.
Okay. So I have, here's what I know. The parties appeared for mediation at the front of the court on February 11 of 2025, and the matter was not resolved. And I want you both to remember that when this case concludes, because I will almost guarantee you both will be kicking yourself for not taking advantage of that mediation, because this is really the last opportunity to control your own destiny, so to speak, in this case, because now it goes from the parties being able to sit down and maybe not come up with a perfect solution, but one that they can work with and go into the future with. But now I have to get involved with it. And a lot of people don't like when courts have to make decisions about kids they never met. But maybe this will work out for each one of you. I don't know. The last parenting time order was the March 5 of 2019 judgment of support. Parenting time was set by the agreement of the parties. According to the motion, and there's always more to it. I know that, but if I've heard this once, I've heard it 1,000 times on these motions. Motion states everything's going great. And then the parties have an argument and it stops. I hear that constantly, and I know there's obviously two sides to every story. That might not be how Miss Lachae sees it, but be that as it may, there are irregularities in service. I get that, and I'm always willing to tell the other side that I would be happy to adjourn this matter and for a couple of weeks and then allow for proper service, that type of thing. But I will tell you, I'm going to do what I'm going to do regardless. So if it probably would not behoove you to take time out of your days to do this. So the lead case in parenting time is the case of Shade versus Wright, 291 Michigan Appeal 17. That is a 2010 case. And what that would say, that says to me, that proper cause or change of circumstance has been shown to take a look at parenting time because there's really not anything to enforce. And parties need, children need, everybody needs structure in these areas. I will also note the unpublished decision of Bauman versus Hartman, that decision not being precedentially binding on this court, but certainly persuasive. And I find that poor communication and lack of cooperation between parents does constitute a change of circumstance to revisit parenting time. The relevant best interest factors are found at MCL 722.23J because it diminishes each parent's ability to encourage and foster a close and continuing parent-child relationship between the other party and the minor child or children. So reluctantly, because like I said, I don't take lightly getting involved in people's business. So reluctantly, I am going to send the matter to the friend of the court for a complete investigation and recommendation insofar as parenting time is concerned. Additionally, there is a request for custody, and it appears anyway that it's not, there's certainly no proper cause or change of circumstance to even do that. So I'm not going to get in that involved, but I'm just going to refer it to parenting time for parenting time. And let me ask you this, Ms. Lachae, are you currently employed?
Yes.
And Mr. Shears, are you currently employed?
Yes.
Okay, so I'm going to send it to the friend of the court. There is a fee for that, and I normally split it. And the fee is $300, so half of that's $150. And they will let you know, keep in touch with the friend of the court, make sure they have your correct information. You gotta know where to pay the when and where to pay the money. And they will do a deep dive into this. They'll talk to whoever you want them to talk to. They will, sometimes they'll speak to the children, maybe not. And they will review whatever records you want them to review. And then they will make a recommendation to me. And then the parties are free to accept it. They're free to use it as a tool to negotiate from. Or they're free to say, nope, I don't like it. And then when that happens, it comes in front of me in by way of an evidentiary hearing. And that's when it gets pretty complicated because the rules of evidence apply. I can give some grace to people who are unrepresented, but I still have to treat you all like attorneys. So you can, I'm going to do the order of reference today, and you should be hearing from the friend of the court relatively quickly. I would say if you haven't heard from them by a week, I would call them and make sure they have your proper credentials because they don't forward mail. So, and I hate for people to run into this problem at this point. Okay. Ms. Lachae, anything further?
Nope.
How about you, Mr. Shears?
No.
All right. You both are all set. Have a wonderful weekend and don't stop trying to get this resolved, okay?
I have one question though. I don't know if this is possible, but is there any way that I can like at least talk to my kids? Like,
well, I usually don't start with interim relief. You can file your own motion if she's not allowing contact, and I will entertain a interim schedule of parenting time, but I need more facts. Okay, so if you wish to do that, then bring it on in another motion and let me have all kinds of facts as to what kind of parenting time you had in the past, what you're looking for in the future, what type, this type of thing. Okay.
Okay.
You are all set with me. Have a great weekend, you two, and we're adjourned.
Thank you.